Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing what is likely to be one of, if not the most important cases heading to the Supreme Court in a generation. This is the case of Hack and Quebec. It's a legal challenge to Quebec's ban on certain public sector employees from wearing religious symbols. Quebec's loi sur la laïcité de l'État, the law regarding state secularism, prohibits certain public figures like teachers, police officers, and judges from wearing religious symbols while on duty. This would include headscarves, turbans, crosses, or kippas. The law is a violation of the Charter guarantee to freedom of religion, so the Quebec government invoked Section 3 of the Charter, also known as the Notwithstanding Clause. This allows government to enact legislation that operates notwithstanding certain Charter of Rights and Freedoms, like the protection of religious liberty. In response to this law, a legal challenge was brought, and that case is now heading to the Supreme Court. There are many different legal issues at stake in the case, including the right to freedom of religion, as well as how Section 33 is supposed to work. And there is a record number of interveners, and the charity that I work for, the Canadian Constitution Foundation, is one of those interveners. Here today to talk about the case is Josh DeHaas from the CCF. Thank you for joining me today, Josh. Let's start with Bill 21, which is at the center of this litigation. What is Bill 21, this law banning religious symbols? How does it work?
So how it works is essentially if you want to be a teacher or a school principal, if you want to work, as a crown attorney or be a judge in the province, you are forced to choose between your religion and your job potentially. So if you want to be a teacher, you're not going to be allowed to wear a hijab. I mean, it also applies to, conspicuous large crosses, things like that of other religions, but it's generally Muslims who are affected by it, as well as Jewish people who might wear kippas. So it's saying that in Quebec it's a secular place, and in these particular jobs, you're simply not allowed to have those religious symbols,
as well as Sikh turbans for Sikh men. So how does Quebec justify this law? They say this is about neutrality of the state, but how does that actually? What do they mean by that?
Well, Quebec has a different history than the rest of Canada. If you know a bit about the Quebec history, it was a place where the Catholic Church historically had a lot of control. And then they went through what was called the Silent Revolution, where the state became a much more muscularly secular place. And so they justified this as, in order to be secular, in order to not have any religious influence in government, we have to be very strong against things like religious symbols. But there's another side to this, and that's that there are a lot of people who just don't want to see, Muslim people or Jewish people in these types of jobs. And so, the state says they're doing one thing, but other people see it a different way.
Now, Section 33 of the Charter was invoked when this law was passed. Maybe you can explain why Quebec felt the need to invoke Section 33. I said in the intro that this law is a violation of the right to freedom of religion, although no court has actually determined that, because Quebec invoked this before there was any court determination. So what did invoking Section 33 actually do when this law was passed?
Yeah, so what Section 33 does, and there's very little dispute about this, is it does end the conversation about whether or not this law is going to stay in force for a 5-year period at a time, regardless of what a court might or might not find about it. And in this particular case, it seems pretty obvious that the courts would have found that freedom of religion and also probably freedom of expression were violated. And in fact, when this went before the first court, when it was first challenged, the judge did say this violates freedom of religion and this violates freedom of expression, but because of the notwithstanding clause, I have to allow it to stand anyway.
Yeah, that's actually an interesting part of the case as well, about whether or not the court actually can issue declarations once Section 33 has been invoked. As I said, there are a lot of different angles to this case, but I think it's pretty clear that if Section 33 would not have been used, that this law would have been struck down by the lower court. We've got to go to commercial break now, but we will be right back. Welcome back to Canadian Justice, where we are discussing the legal challenge over Quebec's secularism law that bans certain public officials from wearing religious symbols while on the job. That case is heading to the Supreme Court. The charity that I work for and that Josh DeHaas, my colleague joining us here today, that we work for, the Canadian Constitution Foundation, they have been granted intervener status in the case. Now, Josh, I described this case as maybe the most important case heading to the Supreme Court in a generation. Do you agree with that assessment, and why?
I think that's probably right, and it might not be obvious why to the average Canadian out there, but I'll try and explain why. So this is really about who has power in Canada, whether it's the democratically elected governments or whether it's the judicial branch, who are unelected but are guardians of the Constitution, and who gets a say in these things. So one of the major issues, and it's true that the applicants are trying to overturn this with some very creative arguments on, why it can't stand as a law, even though the government has invoked the notwithstanding clause. One of the bigger issues is whether courts can even say that this violates rights or not, or whether invoking that clause just ends the conversation, at least until the next election. So, some people argue that if the courts can say this violates rights, then that defeats the purpose of the notwithstanding clause, and it gives judges far too much power to undermine governments. Others say that if they can't say that, then they can't guard the Constitution and let voters know that, in fact, we think this is an unconstitutional law and you should consider potentially voting out that government in the next election. So it's really about who gets to decide what in this country and how much power the courts have versus the democratic branches of government.
Yeah, there's so many different interesting legal issues in this case. It's more than just about freedom of religion. It's about that dialogue, you might call it, between the courts and Parliament, and whether or not a moot declaration, a declaration by a court, can even be issued once Section 33 has been invoked. And it kind of gets even to the purpose of Section 33. That's not actually the issue that we are intervening on. We're intervening on something else because there are so many angles to this case. But before we get to that, one of the other angles is actually the preemptive use of the notwithstanding clause. So Quebec invoked the notwithstanding clause before any court had considered this law. Sometimes the notwithstanding clause will be invoked after a court has issued a decision in a legal challenge, and this speaks to this dialogue theory about Section 33, that its Parliament then responds to the court's decision by invoking Section 33. But in this case, Quebec invoked it before there was a court case that had even happened. And that's perhaps described as a more controversial use of the notwithstanding clause by some. What can you explain that argument, Josh? What's the big deal about preemptive use?
Yeah, so the big deal is that if you think about what the notwithstanding clause does, is it says we're going to do this, we're going to pass this law, regardless of whether or not a court may say it's unconstitutional. And if governments did that in every single bill that they pass into law, then you would essentially have no rights because there would be nothing left. So the notwithstanding clause is really sort of a safety valve. It's sort of a measure of last resort, where some people would argue where a court has said that the rights are violated and got it wrong. So there are cases where you can think of a judge maybe got something really badly wrong, and that can't be the final word, and the Democratic branch has to step in and correct that. But if it's used all the time, you don't have many rights. And the same argument goes with this preemptive use. If you're not even giving the court a chance to say that this law is or is not constitutional, then you're sort of sidelining the court, and they're not giving voters what they need to know when they go into the next election. At least that's the argument against preemptive use. So there are a lot of people out there that say, yes, this is part of our Constitution. Yes, this sort of safety valve exists and we can use it in rare cases, but let's at least let the courts have their say and tell us what they think of these laws.
And that's an important thing to emphasize, of course, that Section 33 is a part of our Constitution. So when people talk about how it's being used, that's always an important thing to keep in mind. We've got to go to commercial break, but when we come back, I want to talk about how it ended up as part of our Constitution and why it's in there. We will be right back. Welcome back to Canadian Justice, where I'm joined by Josh Shahaz of the Canadian Constitution Foundation to discuss what I think is probably going to be the most important Supreme Court case in a generation, the case of Hack and Quebec, which is the legal challenge to the religious symbols ban in Quebec and the province's use of the notwithstanding clause. Now, the use of the notwithstanding clause is often controversial. It's never been used by the federal government, but it's been used many times by Quebec. Josh, how did the notwithstanding clause, Section 33 of the Charter, end up as part of our Constitution? Why is it even in there?
So when the Constitution was being proposed, and remember it was Pierre Elliott Trudeau who was proposing that we have this written Bill of Rights, some premiers were worried. And the interesting thing about this bit of history is that it was premiers on the left. So the Saskatchewan Premier Alan Blakeney, who was worried about giving all of these rights with no way to push back against the court in the context of labor. So he was worried that there might be judges out there that say certain labor rights can't be restricted, or they can be restricted in certain ways that the NDP would disagree with, and so we need something to push back against that. And also conservative premiers like Peter Lougheed and Sterling Lyon of Alberta and Manitoba, who were also worried about judicial activism, because the thing is, when you have courts decide what the content of particular rights mean. What does your free expression really mean, and what are the limits on that? What does your freedom of association really mean? What are the limits of that? If they're just the final word, then when they make bad decisions, there's no way to correct those. So the notwithstanding clause is a sort of brilliant invention unique to the Canadian context that got these premiers to sign on, because it said that in the general case, the courts will decide and they'll let us know what the contents of rights are. But in those rare cases where perhaps they do get it wrong, there are ways for the democratic branch of government to correct that.
Yeah, and a lot of people have argued, I think persuasively, that we probably would not have a charter if we did not have Section 33. Now, the CCF is intervening in this case, in the case of Hack in Quebec, this challenge to the religious symbols law. And we're intervening on a really specific issue about how Section 33 works and what the consequences of using Section 33 are. Josh, can you explain what we're going to be arguing?
Yeah, so part of the debate here, we talked a little bit about this earlier in the show, is this idea about, when the notwithstanding clause is invoked, does that just end the story? And, judges can't say that, rights are violated and this would be overturned if it weren't for the notwithstanding clause or not. Some people are going further and saying that once the clause is invoked, yes, you can't overturn the law, but that people affected by it might be able to get damages. So in Quebec, to use that example, Bill 21 would stand and you wouldn't be allowed to be a teacher wearing a hijab or a kippa, but you could sue the government and get money. And all we want to argue is essentially that when you look at the Constitution, this would not be just and appropriate under Section 24 to invoke damages. So regardless of whether or not the court decides that these declarations that rights have been violated are available, we don't think it would be constitutional to then award damages. We think that would undermine Section 33 and the structure of the Charter in general.
It would, in fact, create a new collateral consequence for using Section 33 that doesn't seem to have been anticipated by the drafters of it. It would put a provincial chill on the use of this mechanism that wasn't really intended.
Yeah, that's right. So if you accept, and it's hard not to, that Section 33 is part of the Constitution, it was part of the original deal, you have to accept that governments also, in a practical sense, need to at least sometimes be able to use it. And if governments are on the hook for potentially millions or even tens of millions of dollars in charter damages, then it really ties their hands, and they wouldn't be able to ever use the notwithstanding clause. That's essentially what we want to say, is that if this declaration does happen, that's as far as it can go. It can't go to awarding damages as well.
Yeah, I mean, the consequences would be massive if that radical proposal was accepted by the court. So it's so important that the CCF there is going to be in court pushing back against that strange interpretation. We've got to go to break now, but we will be right back. Welcome back to Canadian Justice, where we're talking about a landmark case headed to the Supreme Court of Canada, a legal challenge to the province's ban on religious symbols worn by certain public sector workers, and the province's invocation of Section 33, the notwithstanding clause of the Charter. The Canadian Constitution Foundation will be intervening in that case. Josh is a lawyer with the CCF, as am I. And there actually are a record number of interveners in this case, Josh. There are dozens of them, I think more than 30 at least. Who are some of the other interveners? And why are there so many? Is that good that there are so many? What are we supposed to make of this?
There are a lot of interveners. It's true. There are, Muslim advocacy groups you might expect to be there, Christian advocacy groups, English school boards, feminist groups, the civil liberties organizations like our own, as well as the CCLA. There are a lot of interveners, and interveners are supposed to be allowed to make arguments where they have a unique perspective to contribute, or where their rights might be affected. So there certainly should be some interveners in this case. It's a really important case, but when you start to get into dozens and dozens of interveners who each get 5 minutes to speak, as well as a 10-page factum, it's probably pretty overwhelming for the court to deal with. And I'm not sure how much use there is to having all of these interveners, but we're certainly happy to be there, and we'll make the best use of our 5 minutes that we get to talk at the Supreme Court.
Yeah, I imagine they're going to need days dedicated just to hear all of these interventions. And some of these are interventions as of right. So other provincial governments who are allowed to participate in the litigation. But some of them, like our organization, had to apply to make a specific argument and convince the court that we deserve to be there and we're going to be making a substantial contribution. Now, this is not the only piece of litigation out of Quebec dealing with religious liberties. This September, the CCF will also be intervening in another case in Quebec about, it's actually not related to the secularism law, but it's related to secularism policies in that province. And it's a ban on prayer in public schools by students. So if you are praying on Quebec school property, you are not allowed to do that under this new law. Josh, can you tell us a little bit about that law, how it relates to Bill 21, if it does, and why the CCF is so interested in this case?
Yeah, so this policy was put out by the school board. Again, Quebec will argue that this is necessary to protect its secularism and its very strong view of secularism by keeping students out of classrooms if they're trying to pray, or even in the schoolyard, forcing them to leave school property, even in the middle of winter if they want to just pray visibly on school grounds. Others will say that this is this is bigotry. It's religious bigotry to say that certain students should not be allowed to silently pray, which is not really impacting anybody else. It's It would be one thing if the teacher was engaged in prayer or was somehow involved in encouraging this, but what's really happening is that students are just on their own praying in empty classrooms or outside in the schoolyard. And that type of thing should obviously be protected in a free country like Canada. We don't think that's right. And so we're pushing back against that with our intervention.
Yeah, I mean, this case is very different from the hack case, the case in about the school prayer, because hack applies to public officials in the performance of their duty. These are students. These are not people who are employed. These are students who are simply attending school and might want to, for example, make the sign of the cross before eating their lunch, or they're Muslim students who might want to pray during one of the 5 daily prayers. And the Minister of Education in Quebec said that students are only allowed to pray if they pray silently in their heads. And look, the right to religious freedom means that the government doesn't get to tell you how to pray. It's such an important case. Josh, thanks for joining us and telling us all about these two cases.
Thanks, Christine.
We've heard today about Quebec's religious symbols ban and the many legal issues surrounding the challenge to that law. Which issue are you most concerned by? Do you think the law is justified to ensure state neutrality or an unconstitutional violation of freedom of religion? And when should Section 33 of the Charter be available? And what should its consequences be? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.